After a tenant was arrested as part of a narcotics investigation, the county tried to seize the landlord's property under civil asset forfeiture. I'm Tony, and this is Real Estate Investing and Landlord News. Are you an aspiring landlord looking to buy your first rental property? Or perhaps you're a small real estate investor with one or two properties and you're trying to move up to the next level. You could use consulting, and I'm offering consulting here through Real Estate Investing and Landlord News. If you're interested, please send me an email at tony@northomahainvestments.com. All right, so I have an interesting article for you today, and it's coming out of the state of Georgia. Okay, so obviously, usually when I'm talking about stuff, it's about how great Georgia is and how states in the South, they tend to have more pro landlord laws. But there's this process that counties they use when somebody's part of a narcotics arrest, or somebody who is thought to be drug trafficking, right? And it's called civil asset forfeiture, right? And basically what it does is it allows the county to take property away from people who are charged with drug dealing, right? So that they, the thing that they have, if they use the proceeds from drug dealing to buy it, they don't get that back. Okay. Now, I personally, I don't like these laws. Okay. I'm a law enforcement officer. I don't like these sort of laws because, the person has been charged with a crime. They have not been convicted of a crime yet. And yet the laws, they say that, oh, well, the county can seize this asset, right? Well, what happens when the person's found not guilty? Does the person get the asset back? In a lot of cases, the answer to that is no. Okay. And that's where I say, okay, well, this is an unlawful seizure, and I believe that there should be a process for taking, the proceeds from drug deals if they were actually involved in the drug deal and if the person has actually been convicted of the crime. I don't believe in, oh, well, the county can just come in here and take whatever they want from whoever they want just by them being charged with a crime. That's a bunch of garbage. And in this case in particular, because the landlord in this case, right, they were trying to seize the landlord's property when the landlord had absolutely nothing to do with the narcotics investigation or with the arrest of the tenant. The tenant was the person living in the property and who, they had the warrants for, who was suspected of being involved with the crime. And it really, it points out the flaws in this whole civil asset forfeiture thing in the first place, okay? So before I get into the article, go ahead, hit the like and subscribe button, maybe leave a comment down below. Let me know what you think. What do you think of a county saying they're going to take a landlord's property for crimes that supposedly, allegedly, the tenant is committing? What do you think of that, okay? Do you think this should be legal or illegal? Okay, and I'm going to let you know exactly what happened in this case as we, go through the article. Okay, they have the end results of it and everything. So let's get into it. This article is coming from the GeorgiaVirtue.com, and it says, Judge, DA's office presented no evidence for basis of seizing landlord's property and asset forfeiture proceeding. Yeah, and it's a little bit different than the stuff I usually cover, but this could be of use to you if you find yourself in a similar situation. I mean, I don't know what all my tenants are doing in my properties. Hopefully they're not dealing drugs or selling drugs or any of that stuff, right? But if they are they going to try to take my property from me? Hey, it's possible. But anyway, let's get into the article. The Ogeechee Circuit District's Attorney's Office lost an asset forfeiture hearing last week in which prosecutors attempted to seize the property of a landlord because of her tenant's arrest for drugs. Acting on information received in a drug complaint, investigators with the Bullock County Sheriff's Office began an investigation on January 11, 2023, on a property in Brooklet that was occupied by Lauren Lee Cavaney. Cavaney, a tenant, consented to the search, and methamphetamine was discovered inside both the residence and in the utility shed on the property. Cavaney was subsequently arrested and charged with possession of methamphetamine. As of July 31st, 2023, the criminal case against Cavaney had not been adjudicated. According to the paperwork filed in the Bullock County Superior Court Clerk's office, despite the January arrest, there's been no indictment on the case and no judicial action since. After a full 6 months, the case has not even made it to the grand jury, despite grand juries in Bullock County convening at least 3 times a week since Cavani's arrest. Nevertheless, the district attorney's office has filed paperwork to seize the property location where Cavani was arrested, as well as the mobile home and the shed on the property, despite her not being the lawful owner of the said property. Prosecutors are seeking to do this through a process known as civil asset forfeiture. And there's so many problems with what I just read right there, okay? They said that, hey, this lady hasn't even been indicted yet, okay? Maybe the police have charged her with a crime, but, she hasn't been indicted by the grand jury. The case hasn't even begun yet. She's been charged. She has not been convicted, yet the district attorney's office is trying to seize assets. And not even from her. They're trying to seize the landlord's assets. This is so ridiculous, okay? And I don't like the civil asset forfeiture process. I think that it is ridiculous. I think it is unconstitutional. And some places have found that, hey, it is unconstitutional. Unfortunately, that's not the case everywhere throughout the entire country. And it looks like in Georgia, this process is still, legal. It is still being used. But in my personal opinion, it needs to be thrown out. Okay, there's just too much garbage going on with it, and them seizing assets from people who merely have been charged with a crime when they haven't been convicted. It's wrong. It's just dead wrong. I could see them saying, okay, we're going to, prevent, we're going to hold, like, especially in terms of like money or cars or whatever, we're going to hold this stuff until the trial has concluded. But if you don't plan on charging the person within a reasonable amount of time, especially, and yet you want to take their assets, I mean, come on. Two, make sure that you're actually going after the person who is being charged with the crime's assets and not the landlord. Landlord is an innocent victim in this case, and I believe that's a bunch of nonsense. The owner of the property, Wendy Walker, who was not the defendant in any pending criminal case, purchased the property at an auction in 2002 and placed a mobile home on the land soon thereafter for the purposes of making an income-generating rental property. Though she owns 15 plus parcels of land in Bullock County, working as a landlord is not her full-time job. Now retired, Walker worked for more than 40 years in the U.S. District Court for the Southern District of Georgia. So let me get this straight. The lady works for the court, and the court is trying to take her property. This is so ridiculous, okay? And they said, like, she's not involved in this at all. She's not involved in this at all. You know, yeah, I'm so, it's just frustrating reading this article and seeing just how completely screwed up all of this process is. Because you know what, if it was up to me, the civil asset forfeiture wouldn't exist at all. But if it did, if they said, okay, well, this is still legal, it would only be for people who've actually been convicted. Okay, it's pretty simple. The conviction, and then we take their property. And anyone, a third party who is not involved, like the landlord, they would have zero rights to it. So I'm going to skip down a little bit, because I just want to get to the conclusion. And it says here, the judge's order. The case was heard before Judge Ronald K. Thompson on Friday, July 28th in Bullock County Superior Court. While paperwork for the forfeiture process was signed by District Attorney Daphne Totten and the subsequent filings were made by Chief ADA Barclay Black, the case was transferred to one of the newest ADAs, J.B. Edwards, in the 11th hour leading up to the hearing. Walker was represented from attorneys from Statesboro law firm Talby, Rushing, Snipes, Marsh, Hodgins, LLC. After the hearing, Thompson determined that Walker was an innocent owner under the Georgia law and denied the state's request to seize her property, her mobile home, and the shed attached to the property. So, yeah, the judge agreed that, hey, landlord's got nothing, there's no involvement in this case whatsoever. So under their civil asset forfeiture proceedings, right? They have no right to touch this property. But you know, just it points out glaring holes. I'm always talking about how I don't like the government overreaching, the government having too much power. How certain things they go against what the Constitution says, right? How they want to take away our property rights, and this falls into all of those categories. And that's why I brought this article up, okay? Because we have to be careful out there. We have to be careful because they will trample all over our rights. And she yeah, she had her property taken from her, and fortunately, she won this case. But what does winning really mean? She had to hire lawyers. She had to go through months of worrying if she was going to lose her property. Thousands of dollars spent on this legal case, all so she could keep her property that she rightfully owned because of these stupid laws. So yeah, winning is still losing in that sort of situation.